Welcome everyone. I, Dr. Anup Kumar, Assistant Professor, Faculty of Law, Banaras Hindu University. I welcome you all on the Swayam platform for the course titled as Hindu Personal Law, including Marriage and Succession. We are discussing in week first, Module 11, where we are discussing the meaning, concept, and application of Hindu law. Today, I am going to discuss a point: who is Hindu? And before starting anything, I want to explain what we discussed in the last class. We discussed about the origin of the Hindu law, and we discussed that the Western jurist and Indian jurist have a contradictory claims. Indian jurist concluded that Hindu law derived from Vedas. Vedas are Apaurushe. Therefore, Hindu law is supreme. It also applies king as well as the citizens are the persons governed by the king. Therefore, Hindu law is a king of king. But on other hand, Western jurists concluded that Hindu law is based on custom time immemorial, and it was further amended by the Aryan, and now it exists in different form. We also discussed that both the views are incomplete because with the publication and translation of many Smritis, commentary and digest, we recognize that Hindu law gradually developed through Smritis with also help with the commentary and digest. After knowing the entire discourse related with the origin of Hindu law, today we are going to focus on who is Hindu. The learning objective of the today's lecture includes to comprehend the term Hindu, to understand the legal definition of Hindu, and to understand Hindu by conversion or reconversion. Keeping in the view of following objective, we will discuss in detail about who is Hindu. Now the fundamental question is why the question of Hindu is crucial for this subject, and therefore before dealing into the various aspects of Hindu law, it is very important and pertinent to define who is Hindu. The definition of a Hindu is crucial to determine the applicability of personal law. A clear definition also ensures the protection of individual right related to marriage, inheritance, adoption and family matters under the appropriate legal framework. The term Hindu is difficult to define. It encompasses a vast range of beliefs, practices, philosophy, historics, and cultural elements that are often very significant across religions and communities. Friends, the fundamental is if we are not able to identify the term Hindu, if we are not going to define the term Hindu, we cannot ensure the applicability of Hindu law. Because Hindu law is personal law, therefore application of Hindu law is totally dependent on the term Hindu and the definition of Hindu. Therefore, we must understand that who is Hindu in the eye of law for the purpose of the act, friends. For this purpose, we may understand the different perspective. For example, the mullah tried to explain the idea of term Hindu, where mullah noted that the word Hindu does not denote any particular religion or community. It have been a nomenclature used to refer to various categories of people for the purpose of the personal law. This approach is the approach of mullah, may be correct, may not be correct, but I am just quoting and referring the view of mullah. Friends, Hindu can also refer to someone who identifies himself with the cultural, social and philosophical tradition that are deeply rooted in the Indian subcontinent. Therefore, the term Hindu is used in India. Generally, if we are going to inquire the etymological meaning of term Hindu, we are bound to conclude that the term Hindu originated from the word Sindhu, which refers the Indus rivers. Persian used Hindu to describe the land and the people living on the Indian side of Sindhu river because they are unable to pronounce S therefore they are using H, therefore Sindhu subsequently become Hindu, and entire world community and Western scholars try to denote a term Hindu for the Indian people. This is the elementary discussions about the term Hindu. Now I want to focus on philosophical aspects of the term Hindu. The Savarkar let down a definition, asindhu sindhu parayanta yasya bharat bhumika pitrabhu purna bhumasya savay Hindu riti smritah. In this point, Savarkar tried to explain the idea of term Hindu, where he defined Hindu means a person who regarded this land Bharatvarsh from the Indus to the seas as a fatherland as well as his holy land, that is the cardinal land of his religion. Means if you are associated with this culture and tradition and you are considering this land as a land of father and holy land, then you may considered as a Hindu. Your way of worship may be different, your rituals may be different, but if you are emotionally attached with this holy land, you may be considered as a Hindu as per the definition and prescription of the Savarkar. As I already told you that Hinduism is a vast practice, a vast category of tradition, and therefore we are very clear that Hinduism is a museum of belief. There is no rigid system. This is not a closed system like religion. Therefore, defining the term Hinduism is a tough task. Therefore, the observation of Privy Council is very crucial in the case of Rani Bhagwan Kaur versus J.C. Bose, where Privy Council concluded that even if a Hindu started practicing, professing or having faith in a non-Hindu religion, he will not cease to be Hindu unless it is conclusively established that he gets converted in another faith. The idea behind that is, on the basis of the practice, following the rituals, you can't say that a person is non-Hindu, because once you are Hindu, generally you can't go beyond the Hinduism. This is the idea, and its idea is also continue with our legislative objectives. Friends, Hindu can also refer to someone who identifies with the cultural, social and philosophical tradition that are deeply rooted in the Indian subcontinent, because we are thinking that India is a natural land of Hindus, and therefore this subcontinent, if your association with this subcontinent is associated socially, philosophically, culturally, then you may be considered as Hindu. Therefore, initially, before the invasion of Muslim ruler, Hindu was purely a geographical term, not a religious one. It simply referred to the inhabitants of the Indian subcontinent regardless of their belief. But after the transaction, after the Persian interpretations, now we are thinking that we are trying to identify the cluster of people when we are deciding and defining the term Hindu. This is the aspects through which we are able to understand the idea of Hindu. Therefore, we can explain the entire concept in that light. It is important to note that the tribal identity is more based on social, cultural and historical factor rather than strictly religious belief. The custom, tradition and practice of the scheduled tribes are also rooted in the Indian subcontinent, therefore they considered as Hindu. Friends, before starting investigation from the perspective of law, I want to clarify you that who is Hindu? A person following Hinduism is a Hindu. Therefore, the fundamental term is, what is Hinduism? Hinduism again is not strictly defined, but Radhakrishnan concluded that Hinduism is a museum of belief. Means this is not a religion. If you are atheist, also Hindu. If you are not involved in worship, you are also Hindu. A person who following Hinduism, practicing Hinduism may be considered as Hindu, and if a person is Hindu, Hindu law will apply on them. This is a sociological understanding, philosophical understanding and cultural understanding about the Hinduism and who is Hindu socially, culturally, friends. Now as a student of law, I want to inquire a kind of definition which is prescribed under section 2 of the Hindu Marriage Act or any other legislations regulating Hindu personal laws. They try to identify a term. Although the marginal note of section is different, application of Hindu law, but the ultimate interpretation and outcome of section 2 is you may able to know the exact definition of Hindu. Therefore, section 2 is very crucial for the purpose of legal understanding of the definition of Hindu. Therefore, I want to focus on section 2 of the Hindu Marriage Act, and I am very particular about the section 2 subclass 1 subclass A, where Hindu Marriage Act contains that any person who is Hindu by religion in any of its form and development, including Bir Saiv and Lingayat, or as the follower of Brahma Prarthana and Arya Samaj, will considered as Hindu. Friends, we focus on the terminology, any of its form and development. Any its form and development means definition is illustrative in nature. This definition not let down the exhaustive list. Bir Saiv and Lingayat, a tradition developed during the 12th century in Karnataka, and their followers are also known as Hindu. And simultaneously the Brahma Samaj, Prarthana Samaj and Arya Samaj also a kind of tradition which developed in India, and their followers are also known as Hindu. But the important point is any its form and development means this is a illustrative list. Enumerations are not exhaustive. Means why exhaustive? Not exhaustive because many known and unknown sect is still residing in this holy land. We are not aware about them, and we are not able to include each and every sect prevailing in India. Therefore, section 2A is focused on an illustrative list. On that basis, you are able to understand the definition of Hindu. Scholars concluded that section 2(1)A means Hindu by religion. If you are Hindu by religion or if you are the follower of any of its form and development, you will be considered as Hindu. Friends, for example, we have many different sects. For example, Satsangi cult, we may also Radha Swami cult, many other cults are there. Therefore, section 2(1) let down an illustrative list. On that basis, we are able to understand the idea of Hindu by religion. And this list is illustrative list, and which includes many persons, many sects under the ambit of the definition of Hindu law. Now I want to focus on section 2(1)B. The scholars conceptualize section 2(1)B as person included under Hinduism, or Hindu law applies on these people. Section 2(1)B focus that any person who is Buddhist, Jain and Sikh by religion also considered as Hindu. This class means the person Buddha, Jain and Sikh also considered as Hindu. Friends, nowadays we are thinking about differently, but traditionally the Privy Council of India applied Hindu law on Jain community, apply Hindu law on Sikh community. Sikh argued that they are Hindu because of the justice and equity, but Privy Council rejected this argument and are concluded that you are a Sikh, you are Hindu because you are the follower of Hindu religion. Means in India, if you are associated with another practices which evolve within the great Sanatan tradition, you may also considered as Hindu. You are Hindu and law also considered you as a Hindu. Therefore, Buddhism, Jainism, Sikhism and their followers comes under the periphery of Hindu terminology. Why? Because these sects evolved within the Indian traditions. They are the part of great Sanatan tradition. Therefore, they also included under the definition of Hindu. Friends, now I want to focus on section 21C. The 21C is coined by the scholar as a residuary definition of Hinduism. Means if any other person domiciled in the territory to which the act extends and you are not Muslim, Christian, Parsi and Jew, you will considered as Hindu. This definition is negative definition. If you are not Muslim, Christian, Parsi and Jews, then you will considered as Hindu. Why such kind of terminology is mentioned? A person may residing in India will be considered as Hindu because we are not able to trace each and every person's religion. Therefore, they automatically comes under the domain of Hindu law. Section 21C further clarify that if you are thinking that you are not Hindu, please prove your case. If you are not able to provide evidence that why you are not governed by Hindu law or any customs and traditions as the part of Hindu law, you will considered as Hindu. So how we can conceptualize the class A, B and C? Class A means Hindu by religion, means any person Hindu by religion is Hindu, either any its form and development including Bir Saiva Lingayat and the follower of Brahma Prarthana and Arya Samaj. And if you are Bauddha, Jain and Sikh, you still consider an Hindu. And residuary definition, if you are not Muslim, Christian and Parsi and Jew and you are domiciled Indian, then you are also treated as Hindu unless and until you prove that you are not governed by Hindu law or any custom of Hindu law. So this is the impact of section 2 subclass 1, and it elaborates, extend the definition of Hindu term widely, friends. Section 2 subclass 1 also includes illustrations, how we can identify the religion of the children, friends. Therefore, explanation 1 focus on any child, legitimate or illegitimate, both of whose parents are Hindu, Buddha, Jain and Sikh, they will considered as Hindu by religion. Both of whose parent means father Hindu, mother Sikh, you will considered as Hindu. Father Sikh, mother Jain, again child will considered as Hindu. Both of whose parents are Hindu, then child is also presumed to be Hindu under this law. Explanation number 2 is also very clear. Any legitimate or illegitimate, one of whose parents are Hindu, Buddhist, Jain and Sikh by religion, who is brought up as a member of tribes, community, group or family to which such parents belongs or belonged, you will considered as Hindu. How you can differentiate explanation A with explanation B? Explanation A focus on both of whose parents are Hindu, then you will considered as Hindu. But if one of whose parents are Hindu, then you are Hindu or not is totally dependent on a fact, child brought up as. Child brought up as, if child brought up as Hindu, then you will considered as Hindu. And this is a very clear established practices. A case is very famous, Maneka Gandhi versus Indira Gandhi, where in this case the religion of Sanjay Gandhi was questioned. Now we are aware about the fact Indira was Hindu, Firoz was Parsi, but after that, because Sanjay Gandhi brought up as Hindu, therefore Delhi High Court decided that Sanjay is Hindu. So this is the context. Out of that we are able to understand the concept of Hindu term and person who may comes under the category of Hindu. This is the illustration A and illustration B. Now illustration C is also about the conversion and reconversion. If a person converted in Hinduism or reconverted in Hinduism, also considered as Hindu. What is the conversion? Conversion means you renounce your faith and adopt another is conversion. And reconversion, you have unlimited freedom of religion and therefore you have immunity to travel many religion and then again comes under the domain of Hindu law. Therefore, you will also consider as Hindu, means conversion and reconverted peoples also consider as Hindu as per our established practices. And we should also focus on the constitutional provisions. The constitution under article 25 explanation 2 focus on the reference of Hindu shall be construed as including a reference of person professing the Sikh, Jain and Buddhist religion, and the reference of Hindu religious institutions shall be construed accordingly. Means law and the constitutions considered both the categories, everyone as a Hindus. Very interestingly, in the recent past, a court of Madhya Pradesh declared that Hindu personal law cannot apply on Jain. But the High Court struck down the order of district courts because law is very simple and clear that Buddha, Jain, Sikhs also consider as a Hindu and Hindu law will apply on them. Now the fundamental idea about the conversion and reconversion. All the four acts of Hindu personal law are silent on the requisites of the conversion and reconversion. The process, method of conversion and reconversion is never mentioned in our law and in our entire legal and religious tradition of Bharatvarsh. It is very interesting, friends, because we think that dharma is not a subject which may be a subject to be changed, and therefore entire long history of legal text we never prescribe anything about the process and method of conversion and reconversion. Therefore, we have very important case Perumal versus Punnu Swami. In the year 1971, Supreme Court observed that the mere theoretical allegiance to the Hindu faith by a person born in another faith does not convert into a Hindu, nor does a bare declaration that he is a Hindu. The mere theoretical allegiance or only bare declaration cannot convert you from Hinduism, friends. Therefore, for the purpose of the conversion, we should focus on 2 points. One is bona fide belief and actual practice. On the basis of bona fide belief and actual practice, we may consider a person as a Hindu and not Hindu. And we traditionally have no traditions, therefore subsequently Arya Samaji developed a method of Suddhi Karma. It literally means process of purification, and this purification is a process through which Ghar Wapsi is possible, or you can say that conversion within Hinduism is possible. Now I want to focus on the step of conversion by the Arya Samaj. Interested person may approach the Arya Samaj temple and he has to apply for a written application along with affidavit, and affidavit must state that he or she agreeing to conversion based on his or her will, and he bound to produce the documents, proof related with age and proof of residence must be duly signed by the applicant. 2 witnesses were also required for conversion, and after this a yajna may be organized, and after the completion of yajna, the Arya Samaj temple may issue a certificate of conversion, and this certificate of Arya Samaj temple is considered a legal document, and then you may considered as a Hindu by this process. So this is the idea of conversion, and simultaneously, friends, reconversion is also point, because today you are Hindu, you converted in Islam, and after some time you again converted in Hinduism. This process is known as reconversion. And a very interesting case about the reconversion is Marthamma versus Munnu Swami. Munnu Swami was a student of Marthamma. They developed the illicit relationship, and after that Munnu Swami converted in Christianity. And when he came the house of the father, then they again converted Munnu Swami in Hinduism, and they again married Munnu Swami with Hindu girl. This is a fit case of the reconversion, held that Hindu once embraces Christianity, it does not mean that he cannot therefore convert himself to Islam or Hinduism or any other religion of the world. His conversion to a religion is effective only as long as he remains in that religion and does not opt for another. There is no time limit for reconversion if a man's intention to reconvert himself is expressed is definite term. A few hours are also sufficient for reconversion. So therefore reconversion is also very crucial part. But friends, in India we are thinking about the reconversion and conversion, and the caste system is also an issue which should be discussed somehow, friends. Therefore friends, Albangan versus B. Devarajan, the Supreme Court in the year 1984, Justice Chinnappa Reddy observed that Hindu does not lose his caste on his apostasy from his religion. He regains his caste when he converts to Hinduism unless the community does not accept him. This principle applies even where forefather of the converted had abandoned of Hindu religion. In a case of Kailash Sonkar versus Maya Devi, Supreme Court again, Justice Fazalari observed that the caste of Hindu is determined essentially by the birth. When he embraced some other religion, his original caste comes under the eclipse, and so soon as he reconverted to the Hindu religion, the eclipse disappears and the caste automatically revives. The problem of the 1984 Supreme Court judgment is Supreme Court judgment focused on the doctrine of reprobal, means acceptance by the community, but we are living in a constitutional state and therefore we cannot dependent on the recognition of the member of society whether I am Hindu or not, and therefore up to what extent the Supreme Court declared that whether community accepted you or not is not a legal decision. Therefore the point is very clear. With the help of doctrine of eclipse, we may explain that when you converted within Hinduism, again doctrine eclipse disappears and you regain your caste or the caste of your forefather. This is the point which should be focused on that. Before starting the conclusion, I will also focus on section 2 subclass 2, which focus about the tribals community. The plain reading of section 2 subclass 2 is, unless and until there is a notification from the side of central government, no member of scheduled tribes will consider as Hindu. The application of Hindu law restricted in the context of tribals people. But what is the reality and what is the myth? Reality is tribals are Hindu because of the cultural and traditional reasons. They are Hindu, no doubt. Now the question is, friends, what is the purpose of section 2 subclass 2? Section 2 subclass 2 try to protect their custom. Therefore the application of Hindu law will not apply on them. They are Hindu or not? Yes, they are Hindu theoretically, philosophically, culturally and as per practice. And therefore friends, in number of cases before the independence, the Privy Council, federal courts considered tribal peoples as a Hindu. Rajasthan High Court recently concluded that if a member of tribes community adopted Hindu practices and involved in such kind of marriage, then Hindu law will apply on them. In Chabiswar Majhi case, the Supreme Court also used a terminology, tribes who sufficiently Hinduized will also considered as Hindu. What I want to focus with you, friends, the point is very clear, tribes are Hindu. But why section 2 subclass 2 let down a criteria of notification? Because we want to protect the indigenous practices, custom of the tribes. Therefore this personal law will not apply. But in fact Before the independence and after the independence, Indian court applied Hindu personal law on them because of justice, equity and good reason. We must think section 2 subclass 1 subclass C read with section 2 subclass 2. The combined effect of these two, the tribes are also treated as Hindu. So there should be, the confusion should be avoided in that context. Now I want to conclude my entire lectures. The first point is Hindu includes the person born as a Hindu as well as who converts to Hinduism or reconverts in Hinduism without any doubt. This is proved by further discussion. Second, it will presume that the permanent resident of India who is not a Christian, Muslim, Parsi or Jew is a Hindu because an enumeration of all form and branches of Hinduism is difficult to provide. Therefore, if you are not Muslim, Christian, Parsi, you are Hindu. We cannot enumerate each and every sect. Therefore, all other person included in the domain of the definition of Hindu. And the third point, people who belong to the scheduled tribes are also Hindu because of their allegiance to the belief system that originated in India. But technically section 2 subclass 2 focus only the application of the Hindu law due to the objective to protect the indigenous culture and indigenous customs. Now we may think about something, friends. The point is, if a person is born into a Hindu family and does not practice any rituals or visit a temple, is he considered as Hindu? Think over that, friends. Second is, whether the definition of Hindu in law is based on the belief, practice or on birth. Think over that. If a person is born into a Hindu family but does not believe in God, is he still Hindu under the law? So these questions you may think over that while you are comprehending the entire lecture. Now friends, I want to conclude entire discourse. Who is Hindu? The meaning of Hindu may be classified in two broad categories. The one category is, if you are Hindu by religion, you are Hindu. What is Hinduism? Hinduism is a belief system. If you are following the Indian belief system and what is originated and rooted in Indian civilization and culture, you are Hindu. In this context, the number of people residing in Indian territory will considered as Hindu. This is the point. The point number 2 is whether you are Hindu legally or not. In this context, section 2 is very crucial, and section 2 includes 3 dimensions: Hindu by religion, person governed by Hindu law, and residuary definition of Hindu law. 2(1)(c) is very extensive. It includes all the known and unknown sect which is residing in India. They are domiciled in the territory in India. They considered as Hindu. Very interesting point is also mentioned under the Hindu Adoption and Maintenance Act, where a child is abandoned, parentage of child is unknown, also considered as a Hindu. This is very interesting inclusion, and by this we are thinking that this lands, this culture belongs to the Hindu. Therefore, many peoples come under the domain of the definition of Hindu. And explanation 1, any legitimate, illegitimate child, both of whose parents are Hindu, you are Hindu. If one of whose parents are Hindu, then it is dependent on child brought up as Hindu, then child is Hindu. And any person who converted and reconverted in Hinduism will also consider an Hindu. We should also focus on section 2 subclass 3, where we mentioned that the Hindu term must be construed in the light of the definition of section 2 of Hindu Marriage Act, and therefore friends, we are compelled to conclude that the provisions of section 2 is too vast, and therefore number of people residing in this holy land generally considered as Hindu as per law. Thank you very much.